been taking, but also with the Kerala Judicial Academy, where, as they say, his heart is very, very close since it has been one of his brainchilds when it groomed up. And garnishing proceedings is an important aspect as to in the execution proceedings, as to how the bank can help in the third party rights, how those orders can be attached, the interplay of the execution and the attachment. These different aspects one always intends to learn and understand. And since they all say in the execution proceedings that to get a judgment or a decree, it's easy, but to get it executed is more tough. And before we were about to go to with the session live, I was discussing with Justice K.T.Sankaran. He said that this aspect of law is quite interesting and fascinating, but at the same time, it has its own trappings and its own journey to have the fruits of the same. But what are the ways to get the fruits in the right way? Today, we will be taking those understandings from Justice K.T.Sankaran so that we can understand his style of teaching is always to make complicated things simplified and a common man can all understand. And for this reason, his webinars on a platform are doing exceedingly well. Over to you, sir.
Thank you, Mr. Vikas, and thank you all the viewers. And first of all, I thank the organizers for giving me this opportunity to address you. Today's subject is Garnishee proceedings. It is a difficult area, difficult to understand, difficult to apply. But my grievance is that even though on a better coordination with the litigants, you will get opportunity to use it. Many of the lawyers are not doing it. Two reasons. One, they are not interacting with their litigants in the way in which they should do. Two, this reluctance to apply the Garnishee proceedings. See, when a client approaches you with a decree and asks you, sir, you please see that this is executed. First thing you have to ascertain is what are all the assets which belong to the judgment. In what way the execution has to be doing, whether it is to be by arrest and detention or by attachment and sale, all those things under section 51 CPC. And in the course of time, you must also realize that many a times the judgment letter takes the plea of no means. And if the decree holder fails to prove the means of the judgment letter, it is difficult to get an order to arrest and detain the judgment letter in civil procedure. And particularly the banks, they do not have the facilities, they do not have the methods and ways and means to ascertain the means of the judgment letters, their properties, their deposits, their salary and all other details. They do not get the necessary details with the result that many times the banks fail in getting an order of arrest and detention of the judgment letter. Most of the execution petitions filed by the banks and financial institutions fail because of their failure to prove the means of the judgment. One thing I have noticed is that Rule 41 of Order 21 is seldom resorted to. Rule 41 prescribes a procedure of examination of judgment letter as to his property. And he can be compelled to file an affidavit. But see, I have not seen an advocate filing an application under Rule 41. Then another thing is that with the interaction with the litigant, if you come across a fact that the judgment letter has some debt to realize from a third party, then that debt can be attached because it is a property within the meaning of section 60 of the Code of Civil Procedure. 60 details, which are all the properties which are liable to be attached and sold. And debts is one of the items of properties. And all other movable or immovable property over which the judgmentor has a saleable interest, disposing power, that can be attached and sold. So debt is one. So how it works? I will give an example. A has obtained a money decree against B, and B has a debt to realize from C. Suppose A has obtained a money decree against B for rupees 10 lakhs. B has to get 5 lakhs. B has to get 15 lakhs from C. A can get B's debt attached and the amount can be realized. C can be directed by the court not to pay the amount to B, but to deposit the amount in court for payment to A. So therefore, even though there is no privity of contract between A and C, and even though C is not a party to the suit, he can be, notice can be given to C, he can be called to the court, and he can be given, direction can be given to him to deposit the money in court and to pay the amount to A. And if C obeys that order, A's decree for 10 lakhs, B's debt for 15 lakhs, C is summoned. C is asked whether there is a debt due to B. Yes, there is a debt due to B. All right. Don't pay that debt to B. Deposit in court for payment to A. C obeys it and deposit rupees 10 lakhs. Court will pass an order to pay that 10 lakhs to A. And to that extent, C is discharged from his liability to B. So C need pay only the balance 5 lakhs to C. B cannot recover 15 lakhs from C. He cannot. That is the procedure. So in a case where C is not a party at all, and in a case where there is no privity of contract between A and C, C can be made liable to pay the amount. This is in short Garnishee, and C is called the Garnishee. Now please note, I have requested Vikas Chakrat to request all the participants to bring CPC so that you can note it down there. Please note down in a paper the following. A, please note, decree holder. B, judgment debtor. Within brackets, creditor of C. Creditor of C. C, debtor of B. Debtor of B. D, please note as against his name, third person. D is third person. These are all the expressions which may occur in the provisions. The provisions which we have to deal with is Order 21, Rules 46 to 46I. There are other provisions also which we will come across. Please also note other expressions which may occur here. A, attaching creditor. Attaching creditor. B, judgment debtor. C, Garnishee. These are all the expressions which may occur in Rule 46 to 46I of Order 21. Now let us see Rule 46. Order 21, Rule 46. May I read? And I will request you to mark in your book at the particular places A, B, C like that, so that thereafter whenever anybody reads it, he will understand. Attachment of debt, share and other property not in the possession of judgment debtor. In the case of A debt not secured by a negotiable instrument. Please note there, negotiable instrument is specifically dealt with in Rule 46I. Rule 46I. B, a share in the capital of a corporation. C, other movable property not in the possession of the judgment, not in the possession of the judgment, except property deposited in or in the custody of any court. Please note, property not in the possession, not in the possession. Please note, in the possession of the judgment debtor is specifically dealt with in Rule 43. Rule 43 specifically refers to the property in the possession of the judgment. So that rule takes care of that. Then money, property deposited in or in the custody of any court, that is dealt with, that is taken care of by Order 21, Rule 52. Now, these are all the three categories. How it is to be dealt with? The attachment shall be made by a written order prohibiting. In the case of a debt, the creditor from recovering. Please underline the creditor and mark there B. In the case of a debtor, the creditor from recovering, creditor is B, from recovering the debt, and the debtor from making payment, debtor C, until further order of the court. 2. In the case of a share, the person in whose name the share may be standing from transferring the same or receiving any dividend thereon. In the case of other movable property, except as aforesaid, the person in possession of the same from giving it over to the judgment debtor. Underline the judgment debtor and mark B. B. What is this order? In the case of these three cases which are mentioned in A to C, the attachment shall be made by a written order prohibiting in the manner provided in subclause 1 and 2. Subclause 1 to 3. A copy of such order, subrule 2, a copy of such order shall be affixed on some conspicuous part of the courthouse, and another copy shall be sent in the case of a debt to the debtor. Please note C, to the debtor C. In the case of a share, to the proper officer of the corporation, and the case of other movable property except as aforesaid to the person in possession of the same. 3. A debtor prohibited under clause 1, a debtor C, debtor prohibited under clause 1 of subrule 1 may pay the amount of his debt into court, and such payment shall discharge him as effectually as payment to the party entitled to receive the same. Please underline the party entitled to receive the same is B. The party entitled to receive the same is B. So a debtor, that C, will be prohibited from paying the amount to B, and he will be directed to pay the amount in court. That will give him a valid discharge towards the liability which C has got towards B. Now 46A, notice to Garnishee. The court may, in the case of a debt other than a debt secured by mortgage or charge, which has been attached under Rule 46, upon the application of the attaching creditor, please note attaching creditor, mark A. A. Issue notice to the garnishee. See, for the first time that word garnishee occurs here. There is no definition of Garnishee. And from the context, we have to see C is that Garnishee. The application upon the application of the attaching creditor A, issue notice to the Garnishee C, liable to pay such debt, calling upon him either to pay into court the debt due from him to the judgmentor B, or so much thereof as may be sufficient to satisfy the decree and cost of execution, or to appear and show cause why he should not do so. So the court will issue an order, a notice, calling upon him to deposit in court, or if he is reluctant, to appear before court and to show cause why he should not be directed to do so. 2. An application under subrule 1 shall be made on affidavit, verifying the facts alleged and stating that in the belief of the deponent, the Garnishee is indebted to the judgmentor. Garnishee is C, is indebted to the judgmentor B. An affidavit to that effect should be filed. 3. Where the Garnishee pays in the court the amount due from him to the judgmentor. Garnishee is C, pays into court the amount due from him to the judgmentor. Judgmentor is B, or so much thereof as is sufficient to satisfy the decree and the cost of execution. The court may direct that the amount may be paid to the decree holder. Who is the decree holder? A is the decree. There is only one decree here. B has not obtained a decree against C. B has only a debt to recover. That is a difference between 46 to 46I and Rule 53. Rule 53 speaks of attachment of decree. There, in the case of A, B, and C, A has obtained a decree in the case of Rule 53. A has obtained a decree against B, and B has obtained a decree against C. That is the difference. Here, B did not obtain a decree against C. That stage has not come. B has only a debt to realize from C. That debt is attached. That is Garnishee proceedings. Next step, if B gets a decree against C, Garnishee proceedings cannot be initiated, then it should be attachment of decree under Rule 53. We will read again subrule 3, where the Garnishee pays, Garnishee C, pays in court the amount due from him to the judgmentor B, or so much thereof as is sufficient to satisfy the decree and the cost of execution. The court may direct that the amount may be paid to the decree holder A, decree holder is A, towards satisfaction of the decree and cost of execution. 46B, order against Garnishee. Where the Garnishee does not forthwith pay into court the amount due from him to the judgmentor, Garnishee C, judgmentor B, or so much thereof as is sufficient to satisfy the decree and the cost of execution, and does not appear in show cause in answer to the notice. The court may order the Garnishee C to comply with the terms of such notice, and on such order, execution may issue as though such order were a decree against him. Him, underline, mark C. So the Garnishee, a notice will be issued to the Garnishee, the debtor of B, at the instance of A, with whom C has no privity of contract. And then on that notice, what will be the direction? Direction to C will be either you deposit that amount in court, which is due to B, or appear and show cause why he should not do. And the order to be passed by the court is that the Garnishee to comply with the terms of that notice, and that order will be an executable order, and it can be straightaway executed against C. So the Garnishee fails to pay in spite of the order of the court, in spite of the fact that he has got a liability to discharge towards B. Then the order which is to be passed under 46B will enable A to execute that order which has got the effect of a decree against C. So instead of B, A can directly execute it against C. All these tools and techniques are there in the CPC, but still people say it is very difficult to realize the money. there are areas where if you explore, there are answers. There are answers. There are methods and methods. It is true that it is a very, very lengthy order. Order 21 rule 106 rules are there. It is difficult. All right. But why it is difficult? Because it is comprehensive. There are several methods and various changes have been brought in 1976 particular. Now, trial of disputed questions. Then suppose C says, no, I have no liability towards B. Then what will the court do? Court will decide that in spite of the fact that, as I said, there is no privity of contract between A and C. Court will decide. Trial of disputed questions. Where the Garnishee disputes, C disputes the liability. The court may order that any issue or question necessary for the determination of liability shall be tried as if it were an issue in a suit, and upon the determination of such issue shall make such order or orders as it deems fit. So, as if it is a suit between A and C, that question will be decided once for all, in spite of the fact that C is not otherwise answerable to A. But in this proceeding, when such a direction is issued, Garnishee to issue notice is issued, and the Garnishee disputes his liability, then it has to be decided by whom? Not by a separate suit, by here itself, in the same proceeding itself. Provided that if the debt in respect of which the application under 46A is made in respect of sum of money beyond the pecuniary jurisdiction, the court shall send the execution case to the court of the district judge, to which the said court is subordinate. And thereupon, the court of the district judge or any other competent court to which it may be transferred by the district judge shall deal with it in the same manner as if the case has been originally instituted in that court. It may so happen, because of the pecuniary jurisdictional limits of a court, A and B, it is within the lowest grade, court of the lowest grade, junior division. And C's liability towards B is for a sum of money beyond that, beyond the pecuniary jurisdiction of the junior division officer's court, that is the Munsi's court. Then the Munsi's court in which A's proceeding is there, that will be sent to the district judge. District judge will transfer it to the competent court, either try it or transfer it to a competent court which will decide that issue, as if the original proceeding were there before that. That is on the pecuniary jurisdiction aspect. Now 46D. Procedure where debt belongs to third person. Third person is D. Where it is suggested or appears to be probable that the debt belongs to some third person, or that any third person has a lien or charge on or other interest in such debt, the court may order such third person, D, to appear and state the nature and particulars of his claim, if any, to such debt and prove the same. C says, I have no liability towards B. I owe a debt, but that is to B. I do not owe a debt to B. Then that question will be decided. Issuing notice to D. Order as regards third person. After hearing such third person, please mark D. And any person or persons who may subsequently be ordered to appear, or where such third or other person or persons do not appear when ordered, the court may make such order as is hereinbefore provided, or such other order or orders upon such terms, if any, in respect of the lien, charge, or interest as the case of such third or other person, as it may deem fit and proper. or when it appears that it is not C that who is liable to B, but D. Then also this procedure can be. 46F, payment by Garnishee to be valid discharge. Payment made by the Garnishee, that is C, on notice under 46A or under any such order as aforesaid shall be a valid discharge to him as against the judgment and any other person ordered to appear as aforesaid for the amount paid or levied, although the decree in execution of which the application under 46A was made or the order passed in the proceeding on such application may be set aside or reversed. Take the extreme case. Notice is issued to the Garnishee. Garnishee complies with that notice. He pays the debt in court for payment to A, and the amount is paid to A. Suppose the decree under which the direction is given is set aside or varied or reversed in appeal. What will happen to the payment made by C? Pending appeal, execution can be levied if there is no stay. A obtains a decree against B. It is executable. B can file an appeal. It is not always possible to get a stay, or there may be a conditional stay, and the appellant B has not complied with that condition. Then the stay will go. A can execute the decree pending the appeal. Suppose the appeal is reversed. The appeal is allowed and the decree is reversed. Then section 144 will apply. Restitution. The parties will be put in the same position which they would have occupied, but for such variation or reversal or setting aside. That is 144. But here a third party's intervention is there. A third party, namely C, is directed to pay the amount in court. What will happen to that payment? So far as C is concerned, that is final, conclusive, notwithstanding that the decree may be varied or reversed. Then we may recover that amount from whatever is necessary is another thing. After hearing such third person and other person or persons who may be subsequently so and so, the court may make in such order as in herein before provided. I'm sorry, 46. Yeah, I was reading 46F. Sorry. Although the decree in execution of which the application under 46A was made or the order passed in the proceedings may be set aside or reversed, even if it happens, what will be all right? First part of the rule. Payment made by the Garnishee on notice under 46A or any such order as aforesaid shall be a valid discharge against the judgment, even if the decree is reversed. So far as C is concerned, compliance with the order of Garnishee is final. That discharges him from his liability towards B. Whatever happens between the happens in the litigation between A and B, C is unconcerned because he has complied with the direction issued by the court. C need not worry about the subsequent allowing of the appeal and setting aside the decree which A has obtained against B. What happens because the appeal is allowed? A's decree against B, B's appeal is allowed. That means A has no decree to be executed against B. Then how can A realize the amount which B has to get from C? Cannot. But it happened during the pendency of the appeal. Then what should be done? Restitution is the remedy. A has received the amount which he is not entitled to. From whom? From C. C is protected. C is discharged from the liability, even though the decree is reversed. C cannot be made liable because he has only complied with the direction by the court. C, you are relieved. Then as between A and B, what happens? B has to get the amount from C. That amount has been paid to A. Restitution takes place and A will be made liable to pay the amount to B by way of restitution, by way of putting back the parties in the same position which they would have occupied but for such decree or all. So whatever happens to the decree between A and B in the litigation between A and B, that is, C is unconcerned about it. So it reaches a stage where in execution of a decree which A has obtained against B, that decree itself vanishes. Still the result continues. Then it has to be repaired in the same proceeding under section 144. How? He will be directed to pay back the amount to B. That's all. Then the whole thing is cured in the same proceeding itself. No separate suit, no other worry, nothing. Cost. The cost of any application made under 46A and of any proceeding arising therefrom or incidental thereto shall be in the discretion of court. Then appeals. 46H. An order made under 46B, 46C or 46E shall be appealable as a decree. Why it is true? Wherever in the CPC, a third party's rights are determined for the first time without his being a party to the original proceeding. The order passed thereon is deemed to be a decree and an appeal is provided. So that justice is provided to see. If it is only an order in execution, then it is only revisable, not appealable. But when C comes there for the first time, an appeal is to be provided. That is why the order passed the Garnishee proceedings under 46A, 46B, 46C, and 46E shall be appealable as if it is a decree. You will find similar provisions in somewhere else also. For example, Order 21, Rule 58. Objections and claims and objections to attachment. Or under the scheme of Rule 97 to 104. An order is passed under Rule 103. An order is passed under as provided under Rule 101. The Rule 103 provides that the order shall be appealable as if it is a decree. So whenever such things happen, an appeal is provided. That is provided here also. Application to negotiable instruments. The provisions of Rule 46A to 46H shall, so far as may be applied in relation to negotiable instruments attached under Rule 51 as they apply in relation to debts. So that applies to negotiable instruments as well. Now the other rule which may be relevant in this context is Rule 52. Rule 51, attachment of negotiable instruments. 51, attachment of negotiable instruments. When the property is negotiable instrument not deposited in a court, nor in the custody of a public officer, the attachment shall be made by actual seizure, and instrument shall be brought into court. The other provision is Rule 52, attachment of property in the custody of court or public officer. Yet another provision which is also relevant along with this is Order 21, Rule 79, delivery of movable property, debts and shares. How it is effected where the property sold is movable property which actual seizure has been made. What shall be done? Movable property in the possession of some other person. What will be done? The procedure is provided in Rule 79. I am not reading it and spending time on it because it is to some extent it is very easy also. Now this is in short the Garnishee. I do not know why people are afraid of Garnishee. This is all simple but apparently difficult. Now next time when a party comes to you, I am saying, I am sorry, I am not saying to all experienced lawyers, I am giving this advice to you to youngsters. Please don't misunderstand me. I am giving all these advices to youngsters, beginners. So next time when a client comes to you and says that a decree is to be executed, a money decree is to be executed, you have to interact with him. Ask him, what are all the properties which JD has? He says that he does not have any job, therefore no salary. He has no immobile property. He has no bank deposits. Then what else he has got? He has to get money from 3 or 4 persons. Because he had lent money. He was indulged in money lending. And therefore, B has to get several debts from 4 or 5 persons. That is the only asset which he has. Immediately, it must occur to the lawyer. Yes, there is method. In spite of the fact that there is no immobile property for the judgment, in spite of the fact that he has no movables with him, in spite of the fact that he is not a salaried person, no deposits, still these debts are like deposits. Proceed against it, the Garnishee proceedings, and the amount can be recovered. It's easy. So that explore all the possibilities in the matter of execution. And enough time is granted to execute the decree under Article 136 of the Limitation Act. Period of 12 years is the, if it is a ordinary, if it is a decree of any nature, except Article 135, if it is a decree for mandatory injunction, it is 3 years. Otherwise, enough time is there. There are several methods. The modes of execution you will get in section 51. 51 is a reservoir of various powers. 51 of CPC. We cannot say that the court is powerless. Civil court is very powerful. Very, very powerful. And when we compare with the criminal court may be able to see, maybe clothed with the power to punish a man, detain a person, send him to jail, all those things. People will ask, what of the civil court? Civil court also has all those powers. Depends, because here there is no punishment. Procedure in execution 51 powers the court to enforce execution. Various powers are there. And all these powers are connected with various rules in orders and rules. So that we have to connect various orders and rules. If you are interested, please note down. Now it's there. Section 51. Subject to such conditions and limitations as may be prescribed, the court may, on the application of the decree holder, order execution of the decree. Now, various clauses. By delivery of any property specifically decreed, please note Order 21, Rule 35. This is not our subject, today's subject, but I thought that the youngsters can be provided with this information so that it covers a vast area. Order 21, Rule 35. By attachment and sale or by sale without attachment of any property. Please note section 60, 65 to 67 and Order 21, Rules 41 to 54, 58 and 64 to I may say 104, because that includes delivery, obstruction and all those things. Then C, by arrest and detention, etc. Sections 55 to 59 and Order 21, 55 to sections 55 to 59 and Order 21, Rules 11A, 22 and 37 to 40. Clause D, by appointing a receiver, Order 40. Clause E, in such other manner. So these are all the powers which the executing court has. A person can be detained. No harm. Now we'll see what difference it makes, Garnishee proceedings and attachment of decree. I have said it, I will again explain. In the case of a Garnishee proceeding, A has got a decree against B and B has got a debt to realize from C. It has not matured into a decree. So one decree, another debt. Attachment of decree under Rule 53. A has obtained a decree against B and B has obtained a decree against C. That decree which B has obtained against C will be attached and execution will proceed against C for realization of the decree of A. That is the difference. That's all the difference. Then the procedural matters, there is difference. Not much. So now let us see some of the principles and also some of the decisions. Yes. A debt cannot be attached unless it is actually due from the garnishee. Actually due from the garnishee. Next point, it may be either presently payable or payable in future by reason of a present obligation. Presently payable or payable in future by reason of a present obligation. An existing debt, though payable on a future day, may be attached. But an existing debt should be distinguished from a contingent debt. Existing debt can be attached, a contingent debt can be attached only after the contingency happens. In existing debt, the garnishee proceedings can be initiated, but if it is a contingent debt, that will be available only if that contingency happens. Until then, there is no debt which can be attached till that contingency happens. It is not necessary for the purpose of attaching a debt that the exact amount of the debt should be stated. It is not necessary for A to state the exact amount of debt which B has to recover from C. It is not necessary. Exact amount he does not know. But there must be a debt actually due. Next is the attachment of a debt does not prevent the JD from suing the debtor. Otherwise, what will happen? Garnishee proceedings are initiated against C. Suppose A discontinues CCP and the whole thing is dropped. Then B will be in trouble. B suit will be barred. So B can proceed with the suit, no harm. B can file a suit against B even pending the Garnishee proceedings. Does not prevent the JD from suing his debtor or from taking any other step necessary for the recovery thereof. But he is not entitled to receive payment unless the claim of the decree holder is first satisfied. A suit already instituted can be continued also. There is no harm. So the Garnishee proceeding does not stop B from suing C for getting a decree. Does not bar. He can continue the pending suit also. But only thing is that B cannot recover that amount which is payable to A. That amount. A decree for payment of money is not attachable because it can be done only under Rule 50. Now please a few decisions. AER 1962 Supreme Court. 1962 Supreme Court. 1764. That is a constitution bench decision by B.P. Sinha CJI, Justice Gajendra Gadkar, Justice K.N. Vaju, Justice Rajagopal Iyengar, Justice T.L. Venkatramaiah. Justice Venkatramaiah wrote the judgment on behalf of the bench. All very top people. Name of the case is Shanti Prasad Jain. Shanti Prasad Jain versus Director of Enforcement, Foreign Exchange Regulation Act. Please note paragraph 39. The other points are discussed. We are not concerned with that. We are concerned with the Garnishee proceedings. There it is discussed in paragraph 39. In our opinion, on this contention is well founded. A contingent debt, it is not Garnishee. What is the difference between contingent debt and an existing debt? That is a discussion, not Garnishee as such. A contingent debt is strictly speaking not a debt at all. It, in its ordinary as well as its legal sense, a debt is a sum of money payable under an existing obligation. It may be payable forthwith, solventum in presenti, solventum in presenti. Then it is called a debt due. Or it may be payable at a future date, solventum futuro, solventum futuro. Then it is a debt accruing. But in either case, it is a debt. But a contingent debt has no present existence because it is payable only when the contingency happens. And ex hypothesis, it may or may not happen. The contingency may or may not happen. That is a difference between an existing debt and a contingent debt. So far as a contingent debt is concerned, a Garnishee proceedings cannot be initiated. That is the importance of this decision vis-a-vis Garnishee proceedings. AER 1975 Supreme Court 2254. 4 judges, including Justice Krishna Iyer, Justice K.K. Matthew, Justice Ray, and Justice Murtaza Pasal. Name of the case: Hyderabad Cooperative Commercial Corporation, Hyderabad Cooperative Commercial Corporation Limited versus Said Mohiuddin Khadar. Said Mohiuddin Khadar. This Said Mohiuddin Khadar got a decree, filed a suit against the appellant society, cooperative society, and obtained a decree. Decree holder prayed the EP to attach a sum of rupees 4,50,000, which the government in the budget provision has made to the cooperative society. So a budget declaration has been made to pay some amount to the cooperative society. The 4,50,000 forms part of it. That budget provision is there. That was sought to be attached in Garnishee proceedings. Whether it is a contingent debt or a present debt was the question. Paragraph 11 and 12, the discussion. The amount of rupees 4,50,000 was not a mere budget provision, but the documents show that the amount had ripened into a debt and an order for payment to the cooperative society. The sum of rupees 4,50,000 was impressed with the character of a debt due to the cooperative society, and it was validly attached. The contention on behalf of the state that the amount was not brought into court and therefore the provision lapsed is devoid of substance. So it was not a mere budget provision, but it was really payable. The amount was with the Commission of Civil Supplies and the Accountant General. That has passed that stage and it is payable, it has become a reality. So it is really payable. This is what is held. Next is 1977 to SCC. 77 to SCC. 424. Parallel citation AER 1977 Supreme Court. 536. 3 judges. Mannalal K.T.Sankaran and others. Mannalal K.T.Sankaran and others versus Kedarnath K.T.Sankaran and others. Kedarnath K.T.Sankaran and others. Attachment of shares and transfer of the same in contravention of the order of attachment is dealt with. In paragraph 25 it is there. Next is AER 1967 Supreme Court. 1080. Chauthi Prasad Gupta. Chauthi Prasad Gupta versus Union of India. Attachment of movables not in the possession of the judgment. No actual seizure of the property. What is the proper procedure to follow to sell the property under these provisions? What is the proper procedure in Garnishee? It was held, the proper procedure was to sell the property under Rule 64 of Order 21 and then pass an order under Order 21 Rule 79. That is, movables not in the possession of the judgment. If it is in the possession of the judgment, the movable can be actually seized and sold. But it is in the possession of third party. What is to be done? Then it must be sold under Rule 64 and then delivery under Rule 79. Discussion not under 144, 145 CPC. Paragraph 4, a long paragraph, there is a discussion. After attachment has been made in the manner provided in Rule 46, the next step that the court has to take is to order sale of the property attached. Then comes Order 21 Rule 79, which provides that where the property sold is movable property, of which actual seizure has been made, it shall be delivered to the purchaser. That is under 79(1). But where the property sold is movable property in the possession of some other person other than the judgment, the delivery thereof to the purchaser shall be made by giving notice to the person in possession, prohibiting him from delivering possession of the property to any person except the purchaser. That is under 79(2), Rule 79(2). In the present case, there was no actual seizure of property, but attachment had been made under Order 21 Rule 46(1). The proper procedure for the court was to follow was to sell the property under Rule 64 and then pass an order under Order 21 Rule 79(2) for its delivery in the manner provided there. The court, however, went on asking the subdivisional officer to produce the property, and when it was not produced, it proceeded under Section 145 of the Code of Civil Procedure. We agree with the High Court that 145 has no obligation to this case. So, what is a proper procedure? When the property is in the possession of the judgment, actual seizure, then selling it, the garnishee proceedings can be completed. But it is in the possession of some other person. What should be done? By a prohibitory order, prohibiting him from dealing with it, selling it, etc. Then what should be done? It must be sold. And the procedure to be followed under Rule 79(2). This is what is said. It may appear that it is a difficult procedure, but you have to follow. 2009 5 SCC. 2009 5 SCC. 665. Parallel citation AER 2009 Supreme Court 2330. 2330. Food Corporation of India versus Sukhdev Prasad. Shukdev Prasad. That is said that the order is not an injunction order. Passing an injunction order is wrong. Paragraph 8, 17 and 21. That is a discussion. A final or interim order directing payment of money is not an injunction. Creditor bank filed a suit against the judgment debtor mortgagor. At the instance of the defendant debtor, his tenant impleaded as another defendant. So the mortgagor debtor is sued. And there was a tenant under him. He was also impleaded as a defendant. Plaintiff bank, claiming itself to be entitled in terms of the loan documents to receive rents of the mortgage property, but defendant debtor disputing the amount of liability. The said circumstances, it was held that the status of the said tenant was that of a garnishee defendant and not a principal defendant. Direction was merely an interim prohibitory order and not an injunction. Application filed by the defendant debtor under Order 39 Rule 2A, it was held to be not maintained. Order 39 Rule 2A has no application if the order is not complied with. It has to be executed in some other manner. If the property is there, property to be sold, property actually seized, sell it and get it. If it is in the possession of some other person, sell it and get it delivered under Rule 79. If there is a non-compliance with the direction, as the provisions in Rule 46 to 46I provides, it is not Order 39 Rule 2A. This is what is held in 2009 Supreme Court 2330. Now, these are all the Supreme Court decisions which I saw. There is a difference. Different views are there with respect to jurisdictional aspect, namely whether it must be the garnishee must be within the jurisdiction of the court passing the order, that is executing, or if the garnishee is within the jurisdiction of some other court, whether that decree should be transferred, or whether the decree in which A filed the suit can A's decree is there, it is to be executed, that court can do it. You have to note that section 39(4) is introduced by the 1999 amendment of CPC. 39(4) says that it is not a new provision, it is only a clarificatory amendment under 39(4). That was the provision even before, but it was absent there. And it was clarified that this was the position always. What is 39(4)? 39 provides for transfer of decree. 39(4) says, nothing in this section shall be deemed to authorize the court which passed a decree to execute such decree against any person or property outside its local limits of its jurisdiction. This is very clear. The property to be attached or the person to be arrested is within the jurisdiction of another court. Then the court which passed the decree and the court which is executing the decree has to transfer the decree to the court within whose jurisdiction the property is or the person to be arrested is. That is the procedure to be followed. But in Garnishee proceedings, what should be? Conflicting views are conflicting. Even our own High Court, a single bench said that money due from a garnishee outside the jurisdiction of the court, it is still possible to be done by the court which passed the decree. Division bench said otherwise. These are all the different opinions. I will just give the citations. I am not explaining the different views. I will just, if you are interested, you may go through the various High Court's decisions on that point jurisdictional aspect particularly. I will just mention 1961 Kerala Law Times 827 edition by 827 Balkisu Begum versus Gonzago Gonzago Gonzago. Another decision, AIR 1956 Travancore Cochin TC Travancore Cochin 100. Name of the case, Bhaskara Pillai versus Bank of Kerala Limited. Bank of Kerala Limited. The single bench decision which I mentioned is ILR 1991 Volume 2 Kerala. 91 Volume 2 Kerala. 487. Is reported in Kerala Law Times also. 1991 1 KLT 266. Ashokan versus Balan. Ashokan versus Balan. Then there are some other Kerala decisions which I am not giving you the citation because it may not be of that much help to you. Then one decision, division bench, AER 1988 Kerala, AER 1988 Kerala, 285. ILR also ILR 1988 to Kerala, 349. Executive engineer versus Sharma. There it is not jurisdiction, it is objection was raised. Whether what is the procedure to be followed? Detailed discussion is there. Please see paragraph 8. Then AER 1962 Kerala. 1962 Kerala. 233. Shankaran Nair versus Krishna Pillai. Then AER 2004 Andhra Pradesh. 2004 Andhra Pradesh. 321. Aditya Electronics versus AS Impex Limited and others. AS Impex Limited and others. AER 2003 Delhi. 2003 Delhi. 273. Indoor Table Tennis Trust. Indoor Table Tennis Trust and others. Versus Kapil Khanna. Next, AER 1984 Delhi. 90. Wali Ram versus Satwanti Kaur and others. Wali Ram versus Satwanti Kaur and others. Then AER 1980 Punjab and Haryana. AER 1980 Punjab and Haryana. 146. Kumari Renuga Batra versus Greenlace Bank Limited. Now, with these materials being provided, I think the fundamentals of Garnishee proceedings are over. And if there is any doubt to be cleared, you are free to put it. To the extent possible, I will answer.
Yeah. Only one question has so far come, at least on the group. Is a Garnishee a defendant? What happens if a Garnishee doesn't pay?
Garnishee doesn't pay.
Yeah.
Garnishee, an order is passed. If he does not obey, it can be executed against him.
No. First question is Garnishee to be considered as a defendant?
Garnishee is, even if he is made a defendant, once a Supreme Court judgment we saw, a tenant was made a defendant. It is not necessary to make him a defendant because it does not come there at that time. Making a party a defendant is at the trial stage. At the trial stage, as the creditor has no cause of action against the Garnishee. He has not obtained a decree, first of all. Garnishee proceeding arises when A has obtained a decree against B. Then execution comes. Then B's debtor can be proceeded. Then only his presence comes. Otherwise, he is not a defendant. A person cannot be. One example which we saw is a mortgagee's tenant was included as a defendant. Even otherwise, he is a party, proper party. Nothing wrong in impleading it. And then it was held that Garnishee execution proceedings can be proceeded against him and he can be treated as a Garnishee, not as a party defendant. That is it. Otherwise, there is no procedure. It is not proper also. If A files a suit against B, saying that I may get a decree against B and B has got a debt to recover from C, therefore I am making C also a party. No, it cannot be done. Yes.
And what happens if the Garnishee does not pay?
If the Garnishee does not pay, it can be executed against him in whatever manner it is possible, as if it is a decree against him.
Now, one question is from the Facebook. It says, Garnishee can attach the account from the MWC compensation award or no?
I did not follow the question.
He says whether the Garnishee can get the amount attached from the motor vehicle compensation award.
Garnishee can attach.
Can get the amount attached from the motor vehicle compensation.
It's not Garnishee to attach. That question is wrong.
Yeah, that's the only question. No, I think. Yeah. So, thank you. And as Mr. Sankaran had told, that it's a topic where very few people in the legal journey have actually traversed through that. But I think that a lot of questions can be answered in the way you have done. One question, somebody is asking that he can ask himself. And meanwhile, you can connect tomorrow on legal limitation of government and statutory orders under the Constitution of India by Mr. P.V.S. Girdhar, an advocate of Madras High Court and a famous resource person. He also takes his classes in the Nalsar Hyderabad. We are unmuting Mr. Thula Simran.
Yes, it is done. Thank you.
Come on the video. Mr. Thula, come on the video, please.
I think there is some antivirus issue. I'm trying to get there. Okay. Thank you, sir. It is very enlightening session. I have a question.
Yes.
See, usually when we file money recovery suit and then we file attachment before judgment, 38
Yes. Rule 5.
And suppose say he don't have any immovable property, but I know that he has a lot of shares and a lot of bank deposits.
Yes.
And I mean, is there a provision to proceed against them like I proceed against immovable property?
Yes.
That was my question.
It can be done.
And thank you very much. And the same provision, sir?
The Order 38 Rule 5 itself
Okay.
includes not only movable property but other property also. We will verify now itself.
Okay.
Order 38 Rule 5. We will put that question. We will verify now.
Yeah. Yes. And I mean, in furtherance to
Where
that,
Rule 5 of Order 38,
Mhm.
where at any stage the court is satisfied so and so that the defendant intend to obstruct or delay is about to dispose of the whole or any part of his property.
Mm.
Property includes everything.
And what is dispose when it comes to FDs, shares, those things? How can you interpret to dispose, expression dispose here?
Dispose of, it has got several. The word assign is not used. Dispose. Anyway, it can be disposed of. It can be disposed of by sale, it can be disposed of by mortgage, by letting in somebody else, or fragmenting it. Whatever manner it is being disposed of.
Okay.
It has got a larger meaning.
Larger meaning. And I no need to show any proof on that. I can say that he is trying to dispose. Is that okay?
Yes.
Okay. Sir, one more practical question. I got order 38 rule 5. I got the order and they told go ahead and issue the notice to the defendant. Meanwhile, go ahead and attach the property. Next visit, he came and filed wakalat and he brought some other security, some other friend's property, for which I said no. And then honorable judge wrote that we are requesting to furnish only respondent's property. And then after that, he didn't show up. My legal question here is order 38 rule 5. Once it is given, if defendant do not show up for any reasons or dragging, I thought that order itself will become permanent. Is that true? After 48 hours or?
I do not understand the question. Last portion.
I got an order under order 38 rule 5.
Yes.
And notice is given to him. And then I already kept the scheduled property to go ahead and attach it. They told go ahead and attach meanwhile.
Yes.
He came on the next hearing with the wakalat and filed. And he brought other property for which I said no, it is some other's property. It is mere trick to defeat the court and me.
Yes. Yes.
So please furnish this property alone. Then he asked for the time and he didn't show up. My technical point here is that order got effected now, or I should again go ahead and plead to effect it?
Now the attachment must be done by the matter provider. It must be effected.
It is done. So I'll go ahead and apply for CA copies and serve on the register. Okay.
Yes.
Okay. So once it is given,
yes,
it is attached.
Attached.
Okay. Thank you very much, sir. I am thankful to you.
So the last question by Chandrasekhar Rao: is it necessary to issue notice before attachment in case of against a Garnishee?
Yes. Garnishee, that is the notice will be first issued. Calling upon him, why not he pay the amount to CA or answer, appear and show cause why it should not be.
The reasons for attachment, proposed attachment should also be given.
Yes.
Because he shouldn't be groping in the dark or what that notice has to be given.
Correct, correct. An affidavit must be there.
Yes.
An affidavit must disclose all the necessary details. The rule itself says.
So if you can sum it up before we part for the day, what would be the exact procedure if you start off that a notice, an order, then notice, how do you go about it? What is the procedural aspect?
Procedure is, say first a notice will be 45, order 21 rule 46A. A notice will be issued 46A. I will just verify. 46A notice to the Garnishee will be there. Calling upon him either to pay into court the debt due from him or to appear and show. This is the first step. The application the question put by Mr. Vikas Chakra, that everything should be disclosed. Yes, it is specifically provided in subrule 2 of Rule 46A that an affidavit shall be filed stating all the necessary facts. 46A2. Then the garnishee may obey it or not obey it. 46B is the next step. An order will be passed by the court. Then that will have 46B will have the effect of it. If he disputes the liability, that decision, that question will be decided under 46C. 46D, third persons. An order will be passed under 46C. All these orders are appealable as it is a decree. Yes.
Yeah.
1 minute. Nice. I forgot to plug on.
Yes, sir. But that was all the question. Yes. So thank you, sir.
Yes.
It was spot on. We had discussed 1 hour, maximum 130, and we have done it as 1 hour.
Now, because you have fixed a time limit.
No, I only said I have experienced that people always want the time, and especially when the courts have started physical as well as very virtual. So they want that we should have a crisp. Nobody nowadays wants a 5-day match. Everybody wants a team.
Yes, correct. When we do it, see, that has to be done within that. Start correctly, close correct.
Yes. And now even the Honorable Supreme Court has said that you should make your submission in a 30 minutes maximum time span along with 3 pages short note. So they say do in Rome as Romans do. Yes, sir. Thank you, everyone.
Yes, thank you very much. Namaste. Thank you.
Namaste. Thank you. Tomorrow we will connect at 5:30.
Okay.